Yeah, yeah. Salient features of BNSS. The Bharatiya Nagrik Suraksha Samhita 2023 was enacted on December 25, 2023, with the stated objective of repealing the pre-independence, that is 19th century colonial era criminal law. So whatever the criminal law was prevalent during the Britishers' time, this act was enacted so that those laws can be repealed and a new fresh criminal law can be enacted. The BNSS aims to provide for a faster and more efficient justice system to address the issues of delay in delivering justice due to complex procedure, large pendency of cases in the court, low conviction rates, low level of use of technology in the legal system, delay in investigation, and adequate use of forensics. So all these things to protect and to provide a quicker form of justice system, all this the new BNSS has been introduced. Now we will look into the salient features. The BNSS 2 2023 modernizes criminal justice procedure with mandatory forensic investigation, stricter timelines for judicial processes, enhanced police power with safeguards, and comprehensive revision to bail and detention rules. So there are so many changes that has been introduced. Now change with respect to the registration of FIR. This is first information report. Yeah. Now first FIR can now be registered via electronic communications. It will be taken on record on being signed within 3 days by the person giving such information. For example, you can even now call and report, give first information regarding the occurrence of, and then within 3 days you have to go to the concerned police station and give your signature to verify it or confirm the complaint. The BNSS introduces a preliminary inquiry prior to the registration of FIR. Preliminary inquiry is limited to cognizable offences punishable with imprisonment of 3 years or more, but less than a period of 7 years. The same is carried out in a time-bounded manner, that is within 14 days from the receipt of information. A preliminary inquiry has to be done. Lastly, it is mandatory for police to register FIR where information regarding commission of cognizable offence is received, irrespective of whether it has the jurisdiction or not. That concept is known as zero FIR. Once the zero FIR is registered, the concerned police station can transfer such FIR to the police station which has the jurisdiction to investigate the case. Now we will understand the two things: cognizable offense and non-cognizable offense. Okay, cognizable offense means the cognizable offenses are those offenses that needs immediate attention. Okay, non-cognizable offense are like lighter form of offenses. Okay, so when we talk about cognizable offense, they have to take action immediately. Okay, this we will discuss when we are dealing about cognizable and non-cognizable offense. Now we will look into the zero FIR case. For example, when an incident happened, you are calling to some police station which do not have the jurisdiction to take the FIR of your case. But now the concept of zero FIR has been introduced. Now even if the police station does not have the jurisdiction of your subject matter, then also they will report they will register the first information, and then they will send that information to the concerned police station to take further action. But they cannot deny that no, we don't have the jurisdiction, we will not register your FIR. Okay, so this concept is zero FIR. These are new concepts. This was not there, this was there earlier but not with the proper name. Now it has come with a proper name called zero FIR. Now additional powers for attachment and forfeiture of property. Section 107 of BNSS gives the magistrate power to attach property identified as proceeds of crime. And the magistrate may, upon the application of the investigating officer, giving reason to believe that the property is delivered from a criminal activity, pass the following order. Direct attachment of property found to be the proceeds of crime after hearing all parties concerned. Pass an ex parte interim order attaching property if the magistrate is of the opinion that issuing notice to the owner of the property for attachment will defeat the object of attachment or seizure. For example, if beforehand only they will inform that we are going to attach, they will keep their property somewhere else. Okay, so this will defeat the process or the object of attachment. Then upon determination that the property in question falls under the proceeds of crime. Proceeds of crime means it was obtained when they committed the crime. Okay, that is proceeds of crime. The magistrate will direct the district magistrate to ratably distribute the property amongst who were affected by the crime. Then section 86 of BNSS provides that court, upon a written request from the officer below the rank of superintendent of police or commissioner of police, can initiate the process of requesting assistance from the court or authority in a contracting state for attachment or forfeiture of proclaimed offender. For example, the person before used to stay in Karnataka, but now he is staying in Chennai or Tamil Nadu. So what Karnataka police officer will do? They will request the superintendent of police or commissioner of police of the state of Chennai to help them in the process of attachment. Okay, if the person is a proclaimed offender. The intention behind this provision seems to be either to secure the presence of fugitives or confiscate properties of fugitives who are evading someone's investigation or trial and have properties outside the country. Okay, so if the person is evading, he is running from one place to another and trying to evade the process, this can be done. Now, adherence and timeline. The BNSS endeavors to address delay in investigation and trial by providing timelines for completing certain proceedings under the BNSS. For example, committal within 90 days from the date of taking cognizance, which may extend to a period of 180 days. Then supply of police report and other documents within 14 days from the date of production or appearance of the accused person. Then framing of charges before the court of session within 16 days, within 60 days from the date of hearing on charge. So when you will practice, you will see these things most of the time, that they have to frame the charges within 60 days. Okay, so they will wait for 59 days, and at the end of the 68th day they will frame the charge, because if they don't frame the charge within 60 days, then the person has to be acquitted. Okay, they have to be released. So what they will do, on 50th day they will do all this. And then judgment, trial before the court of session within 30 days from the completion of argument, which can be extended to 45 days only on giving specific reasons. So once you are done with the final argument of the case, then the judgment must be delivered between 30 to 45 days. Okay, you cannot delay the judgment process for more than these days. In addition, the trial or inquiry, which will be on day-to-day basis and not more than 2 adjournments, will be granted. So once you have reached to argument stage, you will not be granted adjournment again and again. Maximum of 2 adjournment will be allowed under BNSS. Then change with respect to provisions pertaining to arrest. No significant improvement have been made with respect to the rights of arrestee, except that now the arrestee can inform any person of the fact of his arrest other than just friend and relative, which could also include his lawyer. Okay, now before what used to happen, you can only tell about the facts of your arrest to the friend or any relative or your family member, but now they have also included the word lawyer. As regard the arrest of a woman, the BNSS place an obligation upon the police to inform the relative of the woman where she is being held and the information about the arrest. So if you are arresting a person who is a woman, then you have to tell that where you have kept that woman and what was the grounds for which she is arrested. The BNSS specifically allows handcuffing for certain categories of offenses, like offenders like repeated offenders, habitual offenders, etc. Then use of electronic mode at the stage of investigation inquiry. Yeah. Use of electronic modes at the stage of investigation, inquiry, and trial. So one of the most significant feature of BNSS is the introduction of electronic communications. Yeah. Point number 5. The use of electronic modes at the stage of investigation, inquiry, and trial. So, one of the most efficient feature of BNSS is the introduction of electronic communications and audio-visual electronic means for various procedures under the BNSS. In the line with this objective, the BNSS has introduced new definitions which define the term such as audio, video electronic, and electronic communication. Now, summon to the witness and accused person can be served by electronic communication. The form of electronic communication and the manner of serving such summon in electronic communication is to be provided for by the state government by the way of rules. So before summons, if you have sent through WhatsApp, was not accepted, but now if you are sending the summons from WhatsApp and it is delivered, then it is considered as summons served. Then statements can also be recorded by the investigating officer by the way of audio video means. Similarly, it is also permissible for the investigating authority to supply documents such as police report, etc. in electronic form. Search and seizures can be recorded by audio video means, including the recording of preparation of seizure list. A search without warrant is also to be recorded by audio video means. The recording is required to be forwarded to the magistrate without delay. So now this process of audio video recording will provide a greater form of like faster form of justice, because everything will be recorded, everything will be kept record. So now people cannot change their statement what they have already made. Section 530 of BNSS provides that all trials, inquiries, and proceedings, including the appellate proceedings, may be held in the electronic mode. We know during COVID time also all the courts, everything was running through through laptops and phones and other things only. So this new BNSS has come with the new concepts which they have already applied. Okay. Now, production of devices containing electronic evidences. A court or the officer in charge of a police station can compel production of communication devices which are likely to contain digital evidences. These provisions may give the investigating authority unrestricted use of electronic devices in complete breach of right to privacy as well as privileges. Now, amendment in terms of Satinder Kumar versus Satinder Kumar until CBI. Okay. Now, Section 190 of BNSS, in light of the judgment in Satendra Kumar until, provides that where a charge sheet is filed, the accused is not required to be taken into custody. The provision states that if the person is not arrested during investigation, the police officer will take the security from such persons for his appearance before the magistrate. It further provides that the magistrate to whom such report is forwarded will not refuse to accept the same on the ground that accused is not taken into custody. Okay. So once you have reached into you have already completed the investigation. See, the fear is that the accused will tamper or hamper the evidence. Okay. So once the investigation is completed, and if the person says that, yeah, I will appear in all the whatever dates are given for me, then the person will be released on bail, because then there is a no problem, everything investigation, everything is collected, and he is giving a bond that he will appear. Then the magistrate cannot later say that no, you have to be in custody and all. So okay, so now we will look into police custody. Section 187 of BNSS provides that yeah, he be yeah, surety to be present in the court proceedings. Yeah, police custody. Section 187 of BNSS provides that police custody of 15 days, unless extended, may be taken either all at once or in a staggered manner, means one after the another. It empowers the police to seek custody when it is sought to transit from an extended period, which may be at any time during the initial 40 days or 60 days, as the case may be. Now we will look into a very important thing, that is right of the victim. The BNSS provides for following rights to the victims. See, there are two things, victims and accused. Victims of crime. Okay. So the BNSS provides for the rights to victim which have till date only been provided by the judgment of the court. Yeah, obligation on police to inform the victim of the progress of investigation within a period of 90 days. Obligation on the police to supply the police report and other documents to the victim if represented by an advocate. Withdrawal of prosecution will only be allowed after hearing the victims. A witness prosecution scheme to be laid by the state government. This is mainly to protect the victims and help them to recover from the trauma or sufferings that they have suffered. Then victim compensation schemes, which have largely been an administrative scheme such as Nirbhaya scheme, are to be given at the discretion of the state government. Now, applicability of BNSS. Section 531 of BNSS provides that if there is any appeal, application, trial, inquiry, or investigation pending before the date on which the BNS comes into force, then it will be disposed of, continued, held, or made in accordance with the provisions of Code of Civil Procedure. Okay, so from before 1st of July, if any trial is going on, then it will be conducted according to CRPC. But after 1st of July, if any trial is conducted, any new cases are registered, that will be governed by BNSS. Okay, other trials, everything will be governed by CRPC. Only the new cases that have come will be governed by BNSS, because again there will be confusion now if people are following two types of law. Yeah. Now we will look into the definition and classification of offenses under BNSS. Yeah, section according to section 224 offense, except in the chapter and sections mentioned in subclause A and B, the word offense means a thing that is punishable under or by this Sahita. But in chapter 3, in the following sections, namely subsection 2, 3, 4, 5, or 8, 9, all this, okay. See, I will just give you a general definition of what is offense. So, according to BNSS, okay, what is offense? Whatever is punishable by BNS is an offense. For example, murder. Punishment for murder is provided. It is an offense. Okay, so whatever for which the punishment is provided under the BNS is an offense under BNSS, and nothing is offense. For example, if it is not provided under Sahita, then it is not an offense. Just a general understanding. Yeah, now we will look into cognizable offenses. Yeah, so most cognizable offenses are non-bailable and are of serious nature than non-cognizable offense. So cognizable offenses are non-bailable. So easily the bail cannot be given in these offenses. In cases involving cognizable offense, a police officer may, in accordance with the first schedule or under any law, arrest without a warrant. So whenever the case of cognizable offense will come, the police officer will have the power to arrest the person even without the warrant from the magistrate. As soon as the local police is initiated that a cognizable offense have been committed in their local jurisdiction, the police officer in charge may, with the prior permission of the senior officer, conduct a preliminary inquiry to determine whether a prima facie case for proceeding in the matter exists under section 173 of BNSS. This must be within a period of 14 days. We already know once the FIR is registered, the preliminary inquiry has to be done by the magistrate under section 173 3 subclause 3 BNSS, and it must be completed within the period of 14 days. However, this directly contradicts the Honorable Supreme Court's ruling in Lalita Kumari versus Government of Uttar Pradesh, where it was held that the police officer must mandatorily register FIR if the informant receives discloses any cognizable offense, as mandated under Section 154 of CRPC. While the approach may limit to the number of FIRs being filed and in turn reduce the burden of frivolous FIRs being registered, it inevitably raises concern over the complaint being dependent on police discretion to have their FIR registered or not. Okay, so when police people are doing preliminary inquiry means you are shifting the thing to them. If they find that there is a cause of action, there is something, then only they will register the FIR. So this is a kind of, see, before what used to happen, the FIR, once you have given an information regarding any offense, the FIR is used to be get registered. But now the provision is that within 14 days the police has to do preliminary inquiry and find out whether the FIR could be registered or not. Now, non-cognizable offense. Any offense of which the cognizance cannot be taken by the police officer is a non-cognizable offense. In cases of non-cognizable offense, a police officer has no authority to arrest without a warrant from the magistrate. The police officer must obtain an order under section 174 of BNSS from the magistrate. Once the order is obtained, the police officer may treat the said case in the same manner as that of a cognizable case. So once you have received the power from magistrate, you can arrest that person even in case of a non-cognizable offense. If the police officer at the point time, see, this is very important, okay? If the police at any point refuses to register an offense, the aggrieved party can approach to the magistrate by making an application under section 175 of BNSS to present their case. For example, if you are telling about giving an information about the offense, but the police officer will refuse to register the case, then you can directly make an application under section 175 to the magistrate. Okay, a direction may then be given by the magistrate to the police officer to take the cognizance of an offense. Before approaching the magistrate, the aggrieved party will have from the magistrate. One such an treat the said case in the same way as the cognizable offense. Yeah, so non-cognizable offense. So any offense of which the cognizance cannot be taken by the police is a non-cognizable offense. In case of non-cognizable offense, a police officer has the authority to arrest without a warrant from the magistrate. Okay, but in non-cognizable offense, you cannot arrest a person. You don't have any authority to arrest a person without warrant. Okay. So once such order is obtained, the police may treat the said case in the same way as that of a cognizable offense. If the police at the time or at that point refuses to register an offense, the aggrieved person may approach the magistrate by making an application under section 175 subclause 3 of BNSS to present their case. A direction may then be given to the magistrate, to the police officer to take the cognizance of an offense. So once you make an application to the magistrate, then that magistrate will ask the police officer to investigate into the matter. So before approaching to the magistrate, the aggrieved party will have to comply with section 173 subclause 4 of BNSS to inform the superintendent of police about the failure of the police officer to register their FIR. And the SP or DSP may, on being satisfied that a cognizable offense have been committed, investigate into the case themselves or direct their subordinate to be made by an officer subordinate to him. Okay. As opposed to section 154 of CRPC, which has the jurisdiction centric, a police officer can now register an FIR at his or her police station irrespective of the area where the offense is committed. The police station registering the FIR can then transfer the FIR or investigation to the concerned police station under whose jurisdiction the offense have been committed. Now, the police officer has to register the FIR through the prescribed integrated investigation form 1. A statement of the first information narrating the facts of the incident is required to be recorded by the police officer, and the said FIR under IF, that is form 1, must be signed by the investigating officer. Once the FIR is lodged, it must be sent to the chief metropolitan or judicial magistrate courts in writing within 24 hours of it being registered. So once the case is being registered, it has to be sent to the judicial magistrate. Now we will look into two concepts. One is compoundable offenses, another is non-compoundable offenses. So compoundable offenses are those crimes which the person who have filed the case agrees to drop the charge against the accused person by making a genuine compromise. The compromise should be made without any improper reasons or benefit to the victim. Okay, so for example, some case happened between me and you. Okay, but later we decided to compromise. So there is a process, or there is a sections that can be compromised is given in section 359. So section 359 of BNSS deals with the possibility of resolving offenses through compromise. So the cases that can be compromised are known as compoundable offenses. The offenses are less severe criminal action and fall into two categories as described in BNSS. No court permission needed. These offenses can be settled without needing approval from the court beforehand. Court permission needed. So, in certain cases, the permission of the court is required to resolve the offenses through compromise. Prior permission of the court is required. Then, application to settle an offense through compromise must be submitted to the same court where the trial is going on. You know, even if you have committed some crime, even if you know, these compromise petitions are more prevalent in case and counter case. Okay, for example, family dispute happened, one person has filed a case against the other has also filed a case against the same person, and later they decide that we both will withdraw our case, and at that scenario they just file a compromise petition, and it must be filed in the same court where the trial of the matter is going on. However, some offenses, even though they can be settled through compromise, requires the court permission. These offenses should be settled before the trial begins. If the accused person has already been found guilty and is and an appeal is pending, the court permission is necessary to settle these offenses. The court permission is needed for these cases because these offenses are serious in nature and set a negative example for the society. Okay, so example of compoundable offenses include inciting or taking away or detaining with a criminal intent a married woman, voluntarily causing grievous hurt. Okay, now non-compoundable offenses. Non-compoundable offenses are serious crimes that cannot be settled through compromise. They can only be dismissed or quashed. The reason behind is that the offenses are so serious and criminal that the accused cannot be allowed to avoid punishment. In such cases, it is usually the state or the police that has filed the case. So the idea of victim making a compromise does not apply. So all the offenses that are not listed in section 359 of BNSS are considered to be non-compoundable. Both individuals and societies are affected by non-compoundable offenses. In non-compoundable offenses, no compromise is permitted. Even the court does not have the authority to settle such offenses. A full trial takes place, resulting in either the offender being acquitted or convicted based upon the provided evidence. Example of non-compoundable offenses: causing intentional harm, using dangerous weapons or methods, reckless driving or riding on public ways. So all these cannot be compromised. Okay.